All right. First on my screen, I don't know if we have met before, but attorney Natalie Montgomery joins us. Miss Montgomery, good morning and nice to meet you.
Hello. We've met before, but yeah.
Oh, have we? It's been a long time ago because I'm usually pretty good at remembering. Uh, and on behalf of her client, Jason Beloo, Mr. Beloo, good morning to you.
Good morning, Your Honor.
And Sarah Beloo joins us as well. Miss Beloo, good morning to you.
Good morning.
I have read your client's motion, Ms. Montgomery. Did you get a copy of that as well, Ms. Bellew?
I did, Your Honor.
Okay. Before I turn to you, Ms. Montgomery, one of the things that I was reading, and I know that it was prepared by your client, but one of the things that really jumped out at me in this case is that the parties stipulated in 2023 to increase your client's parenting time so that he now has 165 overnights and now wants 182.5 on a 2255 schedule year round, but he doesn't tell me any proper cause or change of circumstance of why I should even entertain that.
Your Honor, these two have come to a very good co-parenting schedule. Only when it comes to the matter between the two of them of just having the 182.5 is that the sticky point. My client has the children pretty much an equal amount of time, giving like whenever he's the overflow, when plaintiff has to be out of town or she's doing something else with work. He is the one that steps in the breach. So it stands to reason he has the children pretty much the same amount of time. He just wants to be able to have taxing authority in terms of having their taxes, having to be able to have the children on his taxes. Also having a joint custody. They live by each other and everything.
That's kind of what I understand. Ms. Bellew, your thoughts, please.
His argument that he provides the majority of transportation to and from sports activities and religious activities is not accurate. I also provide transportation to and from their sports and their religious activities. We alternate weekends. He forces them to go to church. They do not have a choice with him. I give them a choice. I believe religion should be a personal choice. So on my weekends, if they do want to go to church, I drive them there and he drives them back. When they have lacrosse after school, he picks up daughter, takes her to her practice because he coaches. Shortly after, I take son to his practice. I turn around, I pick up daughter from hers, I take her home. We alternate that. So in my opinion, the fact that he's getting to see the children on my parenting time anyways should be sufficient enough. And he hasn't demonstrated what you said, the proper cause or change in circumstance to get any more parenting time.
Let me ask Ms. Montgomery about, I think your client threw in his prayer for relief or request for relief, something about child support. You mentioned that his pay has decreased,
Your Honor, he did speak with the friend of court about his pay reduction, and they told him to address it in court.
Oh, I see. So how much of a reduction was it?
Jason, can you
Yes, my position was eliminated at my prior employer. So I was laid off and I received 3 job offers, and the one I accepted was the best offer, and it was 75% of my prior annual income.
What were the other 2?
Just a little bit less than that. I appreciated this offer because it also had 4 weeks of vacation where the others had 3. and I enjoy the 4 weeks of vacation so that I can have more opportunities with my kids when they're out of school.
I can't argue with that. But if somebody is in effect decreasing their income because they want more vacation time, that's a.
Oh, I'm sorry, Your Honor. That's not what I said.
I know.
The other
that's
offer was
why-
for 85,000. I accepted an offer at 90,000. This was the best in terms of money and vacation, given the current job market.
Ms. Beloo, your thoughts on child support?
We already received a request for child support review from front of the court because it had been 3 years anyways, so they're reviewing our child support order anyways.
Okay, so that's in the works.
Correct.
Okay. So here's what I'm going to do, Ms. Montgomery. I'm going to ask you and Ms. Beloo to schedule. I'm going to send this to mediation pursuant to MCR 3.216. And the parties can either choose a mediator or the dispute resolution clerk will pick one. I don't even mind if it's at the dispute resolution center because they use a sliding scale based on incomes. I want the parties to talk about this first at mediation, and if mediation is not successful, then you can bring your motion back, and then I will rule on the merits. But and just so you know, my struggle is with the threshold. But if it comes back to me, I assume that it will come back to me with a more robust request at that point. But I'm hoping that mediation can
Your
solve.
Honor.
Hang on a second, Ms. Beloo. First of all, to you, Ms. Montgomery, is there any question on what I need the order to say?
Just mediation, is that what you're talking about?
Yes, and let's find out what Ms. Beloo has to add. Ms. Beloo.
2 years ago, Mr. Beloo requested more parenting time. We did go through mediation. 10 hours later and over $5,000 later, I walked away with less time with my children. I would really prefer not to go through that ordeal again. If there's any way you could rule on it today, I would greatly.
Hang on a second, okay? I don't want anybody to go through that ordeal. So point well taken. We'll do it at the Dispute Resolution Center, Ms. Montgomery. They work on a sliding scale, Ms. Beloo, based on your income, and I guarantee you it won't be 10 hours because if I'm always an honest broker when it comes to mediation. I expect the parties to go at it and go at it in a collaborative method. But if it doesn't work, it doesn't work. But I don't expect $5,000 spent on that at all. The dispute resolution center, most of the time, the fees for that for parties are less than 200. So that'll be the place to go for that. Okay, Ms. Montgomery.
Yes, thank you, Your Honor.
We'll see if that can do it. And hopefully we'll solve that issue and we're adjourned. Thank you very much.
Thank you.
Thank you.